All right. Hey, guess what? Good afternoon. I almost thought it was 9 o'clock in the night, but it's not. Where I am, you just can't tell whatever time it is. But share the link. We have attorney at law. Uh, well, two attorneys are with us. We have a member of parliament and senior counsel Roysdale Ford is with us. And we also have attorney at law Selwyn Peters is also with us. So lots of things we are going to be talking about, but specifically the just concluded case there with the concerning the appointment, substantive appointments of the acting Chief Justice and the Chancellor just concluded. And so with me, or we are expecting in studio with us, Member of Parliament, Senior Counsel Roysdale Ford, and also Attorney at Law Selwyn Peters to discuss this just concluded case. We want them to break it down in legal terms, so to speak, in legal terms. So share the link and let folks know that we are on. I have a couple of other quick questions I want to ask these lawyers. This is becoming a lawyer station. We are awaiting the arrival. Our makeup artist is there. I was told by our operator that we already have one of our guests already in the studio. We are awaiting the arrival of another guest so that we can squeeze some information out of them, so to speak. Selwyn Peters is with us and awaiting the arrival of Roysdale Ford, Member of Parliament and Senior Counsel. So do spread the word and let folks know that we're on. We were cut off immediately after that court's decision as a result of technical problems in our studio. But before we get to them, don't forget that the situation with the forgeries, it's getting way out of hand, and it's not looking good on the part of the PPP at all. It's just not looking good at all. So, you know, we are definitely going to be exposing the PPP regime more and more as it pertains to these sort of revelations that we have coming out of the PPP's tent. So thanks again for joining us. We do have the attorneys are with us this afternoon, and if our operator can just patch them through, let's get some information from them as quickly as possible. We have out of Canada, attorney at law Selwyn Peters. So I started doing puzzles and things like that. I've already read everything I can. Somebody's volume is a little loud. I assume it's coming from the end of Mr. Selwyn Peters. Okay, so yeah. Good afternoon, Mr. Roysdale Ford. Good afternoon, sir.
Hi, good afternoon, Mark. How are you doing?
Yeah, quite well, thank you. Yeah, Mr. Peters, your phone is your mic is muted.
Yes, good afternoon, Mark.
Good afternoon. Let's get straight down into business. But before that, let me thank you guys for taking time out of your busy schedule to be here to explain what just happened with regards to this case here concerning the substantive appointments of the top judicial officers, the acting chancellor and the acting chief justice. Can you break down for our people in legal terms what just transpired with that decision, please? Who's going to go first, Mr. Ford or Mr. Peters? Mr. Ford, you want to take the first bite, please?
Okay, Mark. Good afternoon, Mark. This afternoon, we had the decision delivered by Justice Damon Young on the challenge filed by the parliamentary opposition in the name of Viceroy Jordan, challenging the failure of Irfan Ali and the PPP to comply with the constitutional requirements to engage in meaningful consultation, to obtain the meaningful agreement with the leader of the opposition. Article 127 of the Constitution mandates that the President and the Leader of the Opposition agree on the holders of the offices of the Chancellor and Chief Justice as a substantive appointment to those offices. That is the mechanism that the Leader of the Opposition and the President must agree. But that process commences with the President. And this case was exactly about the failure of the President to initiate that process. So this afternoon, the judge delivered a decision in which he made, I believe, four declarations. Firstly, that it was a mandatory duty on the Leader of the Opposition and the President to engage in that process under Article 127 of the Constitution, that the failure to engage in that consultation is required because you need always to have a substantive holder of the offices, and that the failure to do so places the President and the Leader of the Opposition in a continuous duty to engage in consultation. Um, the judge also ruled that notwithstanding no timeline is specifically provided in the Constitution, that there must always be compliance by the Leader of the Opposition, and particularly the President, in terms of initiating this process. And fourthly, the judge also ruled that it was the failure to engage in consultation was inimical to the interests of the state and to the country, and to by extent the judiciary, in that there's a failure to engage in a process that will lead that there is independence of the judiciary. So I'm just looking back at my notes, Mark, quickly to ensure that I did not misstate what the judge said. She was reading rather quickly, so we were trying to make notes. We're still awaiting the decision, which is to be delivered in an hour. So, Mark,
All right. Sorry, go ahead.
so Mark, what we have today is a decision by the court outlining what is the way forward, in that the President is expected to engage in consultation. Um, the judge repeatedly referred to statements by the judges of the Caribbean Court of Justice about the blotch on the judiciary, and that the failure to have this done constitutes a blotch on the judiciary. But what is clear in my mind, and I respectfully disagree with the judge, even though we are essentially victorious on our side, having been granted declarations in our favor, we believe that the judge should have gone further to specifically make a specific ruling that the President of this republic would have failed to engage in the consultation required to engage with the Leader of the Opposition, because the judge herself admitted that this is a process that must be initiated by the President, and the judge specifically observed that up to now this process has not been complied with, and that you're under continuous obligation to do so. So to that extent, there is some area that I believe the judge did not specifically pronounce upon in a most affirmative and necessary manner. Because you cannot have on one hand a duty to do something, the duty is not being complied with, and the judge's acknowledgement that you remain under continuous obligation to do so, without there being a specific breach on your part to do what is you have an obligation to do. So we observed that there was some reluctance on the part of the judge, in my view, to deliver a specific um, condemnation. And when we speak about the blotches on the judiciary, the blotches on the judiciary, on our legal landscape, I believe we require the judges to make clear and pronounced statements that specifically direct the President, in this instance, to act in accordance with the Constitution. But nevertheless, the decision adds to the jurisprudence of Guyana and the Caribbean, because this case was widely weighted upon by judges and practitioners and legal academics throughout the Caribbean to see what would have been the judge's posture in terms of making a decision of this nature. So we have moved the jurisprudence forward. Is a significant decision in that regard. But as I said before, I'm concerned that the judge did not expressly make a statement of the breach of the Constitution, the failure to discharge his constitutional duties on the part of the judge, on the part of the government, on the part of the President specifically. I believe the implicit condemnation was not enough in the circumstances of this case.
All right, thank you so much, Attorney at Law, Senior Counsel, and Member of Parliament Royce Ford there. Let's get straight over to Attorney Selwyn Peters. On your take on this just concluded court matter, the decision there.
Yeah, I think one important aspect of our decision was she spoke about the state appearing before these judges in very important cases and having a vested interest in the outcome of these decisions. So not appointing these judges in substantial positions place them in a position where the independence of the judiciary is called into play, because certainly in the background, you would think that the judges would be contemplating, hey, if I don't rule in favor of the state, it is possible that my appointment to a substantive position may be in jeopardy. So I think that was a fundamental point that she made, that the acting appointment situation since 2005 has been unsatisfactory, and it has failed to insulate the judiciary from executive interference. And of course, we had that in the Paul Slow case, except in Paul Slow's case, the judge went as far as he could go to slap down the action of the president. This judge didn't do that. Instead, she heaped a lot of blame on the leader of the opposition, when certainly the blame should have been on the president, because the president is a leader. He's the executive president. He runs this country, so he should take the lead. Even if the leader of the opposition is reluctant, he should make best effort and act with, and I'll use the judge's words, alacrity.
Yeah, one quick concern here in watching that decision there, and you just mentioned that judges that are not appointed, they're not substantive judges, that they are reluctant, somewhat reluctant to make decisions that would not be in favor of the government. It's ironic because is she acting in that capacity?
No. Justice DeBone Young is a substantive office holder. She's appointed a judge. All the judges in the judiciary are substantive. It's just the chancellor and the chief justice who are acting, they're justices, but they're acting in their roles as the head of the two courts which they lead.
So all of the judges right now across the judiciary there, the Guyana court, they are not acting. All of them are substantive.
Yes, they're substantive judicial office holders, but the office of the chief justice is an acting appointment, and the office of the chancellor is a acting appointment.
I thought in the past I've heard that some of these judges were actually acting in that capacity. Have you heard otherwise, Mr. Ford, before?
Well, there's some judges. The Court of Appeal used to appoint temporary judges for, I think, 6 months to a year. But right now, there's only 3 judges sitting on the Court of Appeal. There are no, Justice Bulkin was an acting judge, and there were others. There are none at the moment who are acting.
Mr. Ford?
Yes, Selwyn is correct.
Yeah, thank you. And so we have heard in terms of a lot of condemnation in terms of moves that the judge thought that the opposition leader would have been making with regards to the appointments, substantive appointments of these, the Chief Justice and the Chancellor. But from my understanding, when the regime said, when Mr. Ali said then that they want to have these two judicial officers become substantive, the leader of the opposition, Aubrey Norton, said, look, whatever it is, I am in full compliance. I'm in full support of this appointment. I thought it ended right there. Consultation ended. You guys are the legal guys. Roysdale, your take, sir.
Mark, you're absolutely correct. And that is one of the areas that the judge did not specifically bring out in her decision. She referred to the fact that I, representing the leader of the opposition, sent a letter to the president, or sent a letter to Gail Teixeira, outlining that the 2 substantive office holders, Madam Justice Cummins and Madam Justice Roxanne George Wilshire, are the nominees of the leader of the opposition, to the extent that he is prepared to immediately agree to them, and he put it in writing. So when the judge did not pay any attention to the fact that after that letter, the president did not engage in any consultation, even what she spoke about in relation to the role or the period of the leader of the opposition being led by Mr. Harman, though it's not factually correct, even on the evidence before the court. Without getting into that, let us move to the point where Mr. Aubrey Norton became the leader of the opposition. From then to now, there's not been a single act of an initiation of any process by the president. And there was sufficient evidence before the judge to lead her to come to that specific conclusion and to make a specific finding that the president failed to initiate that duty, which in fact she did by saying that there was no substantive appointment. Was there no substantive appointment? The president is under continuous duty to engage, whilst acknowledging that the president is the office holder who must initiate the process, did not make that necessary link in her decision to point again to the fact that the president specifically and explicitly has failed in his duty. Should the judge prefer to adopt a more reserved, I believe, approach, an approach that will lead the reader and the country to come to the conclusion that it is an implicit finding, which it is an implicit finding, but it ought to have been made very clear in the judgment.
Selwyn, please, sir, your take on the fact that after the regime has indicated that they had intended then to appoint these two office holders, the highest judicial office holders, as substantive in their positions, that the leader of the opposition put his hands up and said, look, I have absolutely no objections, none whatsoever. Your take, sir, on that?
Well, I think what we need to do is look to the go forward now. So the judgment was rendered today. I believe that the president and the leader of the opposition should engage in these discussions forthwith in terms of appointing the chancellor and the chief justice, appointing the Judicial Service Commission office holders, appointing a chairman of the Public Service Commission, because all these constitutional bodies are in a flux. The Police Service Commission cannot function without the head of the Public Service Commission. A lot of Public Service Commission members, a lot of public servants, cannot get a lot done because there's no head of the Public Service Commission. Of course, the Chancellor and Chief Justice positions are certainly in a state of uncertainty because these two office holders continue to act. And of course, the court knows that it was aware that this was occurring since 2005. The court referred to Anandla's decision in respect to the bringing into force of the Judicial Review Act. And I thought the court would have been as forceful as the court was in that case in terms of bringing effect to the appointment of these two office holders. The court could have made stronger judgments. It could have made stronger declarations, but we'll accept the declarations for what it is. And certainly we're hoping that the leader of the opposition and the president can, at least one of them, should initiate this engagement within the next week or two. It's been going on too long.
Thank you so much, Mr. Peters. Mr. Ford, you wear the political cap here. Do you see this happening anytime in the very near future, the two, Mr. Irfan Ali and the leader of the opposition, meeting to discuss this important issue?
No, I don't see it happening anytime soon. From the time Mr. Norton would have been the leader of the opposition, he wrote specifically indicating that he is ready to engage in that process. That was received by a very rude letter from Gail Teixeira, basically saying to the opposition, you have no duty to tell us where you need to do and when you need to start it or you part of any process. You must simply wait and murmur not. Don't write telling us about anything. But one of the important aspects of this decision, which is that we were justified in writing, because the court recognized that the leader of the opposition plays a role in this process, and to the extent that this judgment seeks to bring him into the question of whether he is willing to participate in this process, we have indicated our position to reach. We have gone further. We have identified nominees, and there's absolutely nothing anymore that the leader of the opposition could do. Notwithstanding the much talk about engaging in consultation on these two issues, there's been absolutely nothing done by the president. We saw Nandalal making public statements to the extent that they basically have no intention of doing anything. He said that this is a matter must be resolved by way of referendum. So when they want to go by way of referendum, they want to change the constitutional framework, the provisions that mandate consultation. So I don't see anything happening. We will give it the necessary time as the leader of the opposition contemplates necessary in the circumstances. But I see ourselves not moving the process forward. And to that extent, I believe that this decision, to that extent, is itself a blotch on the landscape of the judiciary, on our legal system, to the extent that the judge failed to specifically do exactly what is required in the circumstances, to what my good friend Selvin pointed out in the case of the Judicial Review Act. The court was obligated in these circumstances to specifically fix a time period within the president had to initiate the consultation. And to that extent, leaving it very loose, saying that it's something that must be done with all convenient speed, have a regard to the historic delay and have a regard to the ongoing specific delay in these present circumstances. I believe coming from the court itself did not necessarily deal with the issues that the court found this afternoon and being not consistent with the actual declarations granted. That is a mandatory duty to engage in consultation, that once there's no substantive appointment, the leader of the opposition and the president remain under continuous duty to engage in consultation, even though there's no time period fixed, it must be complied with. And that is inimical to the independence of the judiciary. So when you compare what is actually ongoing and unfolding in this republic against what are the propositions that would have been accepted by the court and the decision this afternoon, there is this this gap between actualizing these declarations by way of an order, which was necessary to specifically fix a timeline for the president to initiate this process.
You know, we have heard, thank you so much, Mr. Ford. If you're now joining us, a decision was made this afternoon by the court. The position was basically to have these
Okay,
two
put it back.
senior,
Put it back on the chair.
these senior judicial functionaries to be appointed and become substantive holders of their offices. Mr. Selwyn Peters, we saw that, again, to repeat the question, the leader of the opposition had absolutely no problem. The previous leader of the opposition had absolutely no problem. People thought that these two ladies would have been become substantive Chancellor and Chief Justice as well. That's not happening. Do you see a reluctance on the part of the regime not to have these two persons appointed, or what is at play here, you think?
Well, I mean, I think that the government of Guyana has no problem with the Chief Justice, Madam Justice Roxanne George, but I think the administration does have a problem with the Chancellor based on the issues that flow from the ruling in the various rulings in Charadas case and a number of other cases. I mean, that is part of the public record. There's no I'm not saying something that is not public. And I think that I do not think that the government would I do not think that the government, whether it's the Attorney General or His Excellency, would appoint Madam Justice Yonat Cummins as the Chancellor of the Judiciary. I don't think they would. I think they would confirm Chief Justice Roxanne George if they can, either to the Chief Justice or Chancellor position, and appoint someone else to fill the other substantive roles. So I think I'm sort of telecasting what I foresee as the sort of next step in terms of when the president moved to appoint a Chief Justice and Chancellor, Justice George will be slated to fill one of the substantive positions, and they're going to move to appoint someone else, either to fill the chancellor position or the chief justice position if they elevate Justice George up to chancellor.
Your take, thank you, Mr. Peters, but your take on that same question, Mr. Ford, on the reluctance of the regime to have these two senior functionaries become substantive in their positions.
Mark, I believe that statements made by ministers of government, I believe Darabhlal made a statement that the chancellor must be derobed, defrocked, removed from a judge, is indication of the government's unwillingness to specifically have Justice Cummins confirmed as the Chancellor of the Judiciary. I believe that they have no interest in engaging in any process that will result in her being confirmed. And I agree with Selwyn that based on statements made by the government, they seem much more of an inclination to have Justice Roxanne George confirmed. I believe that in any event, this is an important issue in view of the government's continued breaches of the Constitution. It is necessary to have these two offices filled by persons who would enjoy the confidence of not only their peers on the bench, but judges across the Caribbean, and more importantly, the people of Guyana.
Mr. Peters, and we're looking at time. I know you gentlemen are also busy in court, but I want to ask a question with reference to the regime. I know when the opposition leader had indicated that they wanted certain appointments be filled and so forth, there was this mandate on the part of the regime, meaning the PPP regime, to force the opposition to recognize this regime as a legitimate regime. You think they're going to push that back again as part of their playing cards, Mr. Peters?
Well, no, I think the posture that the president and the government of Guyana took when they assumed the office and the mantle of the government was that they wanted the opposition leader at the time, Mr. Harman, made public statements that he was not going to recognize the government, and he was not going to recognize Mr. Ali as the president. So in that way, the president took the posture that if the leader of the opposition isn't going to recognize him and his government, then there's no meaningful engagement that could take place between the two of them. We dealt with that in the Hicken case. That was something that prominently came up in the Hicken case as well. And so, I don't think that is the posture right now. Mr. Norton is quite clear that that's not an issue for him, whether the government is legitimate, whether he has to recognize the government or not. The government is the government. He is the leader of the opposition. So I think that impediment or that difficulty in terms of the relationship has cleared up. What needs to happen is Dr. Orphan Ali and Mr. Keaton and Aubrey Norton needs to sit down and they need to work together. They need to have their teams work together with each other to get all these substantive office positions filled. It is indeed a shame that these positions have not been filled and cannot be filled yet. They need to work together for this country. All of them. Mark, I want you to bear this in mind, and it's very important for all of us. Guyana is the world's fastest growing economy. Bear that in mind. The fastest growing economy. Guyana has a lot of wealth. Guyana has a lot of oil wealth. There are going to be a lot of litigation. There are going to be a lot of things happening in Guyana. And we need to have a separation of powers, and we need to have all these positions substantively filled so that there's confidence in our judiciary, confidence in our other independent arms of government, confidence in the government, confidence in the opposition, and confidence in the legislators, so that outsiders doesn't come and exploit these differences that are occurring in Guyana for their benefit. Because we don't win, it's they that win, the outsiders that can pit us against each other.
We're at point well taken. We got a comment here saying thank you guys, but what I see here is a contrived chaos by the PPP government, and the judiciary is coming across as being complicit, whether intentionally or not. Mr. Ford, what is your take on this comment?
Mark, I'll deal with both the comment and what the question you asked, Selwyn.
Sure.
I believe that the whole issue of the government's position, that Mr. Harmon's statement, and the opposition statement generally, that we consider the government illegitimate, is nothing that has changed. Our fundamental position is that the government remains illegitimate. There's no change in that. And to the extent that the court, both today and in the previous decision, Higgins' decision, where the court somehow felt that the parliamentary opposition's position that the government was illegitimate or is illegitimate somehow mitigated or somehow obviated the president's duty to engage in his constitutional duties, was affected. And I have a fundamental problem with that. The leader of the opposition is entitled to take his position. And his position, which we would have seen as manifested in the court today, is that he has a constitutional obligation to engage in consultation when initiated by the president. His position that whether it is illegitimate or not illegitimate, the government that is, has nothing to do with the president's duty to initiate the process. And I believe to that extent that the Chief Justice somehow sort of heap some blame on the opposition leaders, especially Mr. Joe Harmon, because they took that political position is improper and not correct. And today we saw another sort of meandering of that thought, that somehow Irfan Ali is obviated or relieved of his duty to initiate a consultation process simply because the opposition thinks that it is the government is unlawful. And the point of this case, which I believe the public should understand and appreciate, is it is about the importance of constitutional obligations above political narrow interests. So you're the president of this country. The opposition say that you're illegitimate. You have a constitutional obligation to initiate consultation. So we still believe that you're illegitimate. So the president is now going to take a position that he's not going to engage in the consultation anymore, or he has more months to play around, or more years to play around, because the opposition feel that he's illegitimate even after this decision. And that is the problem with the judiciary, I must say, quite frankly, this afternoon. That is the problem with the judiciary, where I believe today and other cases so far are glorious opportunities for this judiciary to point out clearly that it is in fact the guardian of the Constitution, that is in fact an avid and staunch defender of the Constitution, that it will stand up against the excesses of the government. They will stand against the statements being made by the government that will constitute a breach of the philosophy underpinning the Constitution. And to that extent, I believe that the Guyanese people will need to continue to be vigilant, and we will continue to have decisions that will not necessarily be as forthright as necessary, unless the Guyanese people see the judiciary as their defender, and to that extent, failing them, the Guyanese people.
And getting back to Ms. Simon's question in terms of the appearance of the judiciaries being complicit and whether it's intentional or not, A lot of people, in fact, you read some of the comments, they seem to have lost hope or confidence in the judiciary. Mr. Peters?
Yeah, and Paul Slow and I were speaking about this morning, and well, let me not say what he told me because he's a client, but I spoke about the culture of complacency that has infected the judiciary and the legal system in Guyana. That culture, where people, this case was filed since last year, and this is the decision that we got today after close to a year after this case was filed. And public confidence is important in the judiciary. The judge can't, on the one hand, speak about the judiciary not being insulated from interference from the executive, and she can't quote all these harsh criticisms from the former president of the CCJ and the current president of the CCJ, and yet render a tepid decision as she did today. Certainly, we thought she was going in a certain direction, and she swung.
Spin bowler.
It's like the sound that Mark Ferdinand sang, Claudette Swing.
Yeah,
You know?
swing indeed. I want to ask a quick question though, but are you finished making your point, Mr. Peters? Go ahead.
Yes, go ahead. It's okay. We're having a dialogue.
Yeah,
Cut it in.
definitely. Thank you so much, folks who are now joining us. We have a member of Parliament and Senior Counsel Roysdale Ford with us, and we have a Canadian-based Guyanese attorney, Mr. Selwyn Peters. He also practices in Guyana. No stranger to you guys. Where do we go from here as it pertains to this particular decision today? Would you guys be appealing it or not, Mr. Ford, Mr. Peters, anyone?
No, I don't think it's a
Um,
decision that's worth appealing. I think at this juncture, certainly the declarations that she made, um, we're taking all deliberate speed to mean all deliberate speed, which means like yesterday. So I think someone has to initiate this discussion, and certainly Mr. Norton is not above trying to initiate this conversation again. And his senior counsel and shadow attorney general will make the decisions on how he will advise the leader of the opposition to deal with this issue.
That would have been my next question to Mr. Ford, but you caught me with that one there. Uh, were you guys, because listening to the judge's decision, one would have thought in the beginning that this was a straight cut case where the individual who sits there in the office of the president was a dereliction of his duties. But then we saw the spin bowling, the legal spin bowling. Were you surprised, Mr. Ford, at the outcome of this case?
no, I am not surprised, Mark. Don't ask me why I'm not surprised.
I
Because
was just about to ask, but I held back. But why aren't you surprised?
Mark, I believe that having regard to a number of decisions that the court would have made, and not this court alone, I believe that I am in a position to say fairly that our courts have adopted what I believe is a certain um, philosophical school, which means that you must pronounce on the decisions. And there are repeated decisions that are um, made by the courts, which I believe I can see a great degree of um, hesitancy and a great degree of a timid judicial approach to the pronouncements. Um, I believe that those decisions are not consistent themselves with the obligation of the judiciary, and it's not consistent with the expectations of the superior courts, particularly the Caribbean Court of Justice, and what is required as a modern democracy in the Caribbean, and in relation to what are the expectations of the Guyanese people. So, Mark, what we see comparatively across the Caribbean as to the type of decisions that are delivered at first instance in Guyana as opposed to Trinidad or Jamaica or even Barbados or the OECS, you see profound decisions. All the decisions are profound, they're well reasoned, but when you get to the point of manifestation of delivery and meaningfulness, I believe that objectively speaking, as a lawyer for many years of practice and standing, you could see a discernible difference between what are the end product, to put it that way, and what is the end product in a comparative decision in another part of the Caribbean. So to that extent, I believe the Guyanese people are being shortchanged uh, by this approach, which is timid.
You know, well said. Not so long ago, we listened right here on 107.1 FM to the decision rendered in a matter that was it Paul Stowe versus the individual who sits there at the office of the president, and that was a brilliant case. Listening to Judge Gino Prasad compared to what we have heard here today, Mr. Peters, you're
And
smiling.
Mark, and
Right.
Mark, I must say that, and um, I publicly commended Justice Prasad for that decision. And it wasn't because simply I'm the shadow, and therefore I want all the decisions to go against the government. But I believe that what we need to do and the public need to start paying attention to is not just the decision, but it is the impact of the decision on their lives and what it means practically for them in terms of harnessing and limiting judicial, limiting executive excessiveness and lawlessness. And the decision there by Justice Gino Prasad was a very profound decision. It went to the core of the issue. It dealt with the action that was done, and it dealt with it at its source. This afternoon, we had, I believe, with the greatest respect, a great degree of equivocation in terms of the ultimate determination. Because interestingly, the decision that was referred to as Selwyn, and I believe for the public to know, the decision referred to by Selwyn and referred to by the judge, which dealt with the Judicial Review Act, it was a very well-reasoned decision by the Chief Justice in which she concluded that having regard to the Attorney General's obligation to bring the Judicial Review Act into effect and its overall importance to the country and the rule of law and public law litigation and constitutional litigation, that she set a 2-month period for the Attorney General to bring that Judicial Review Act, that legislation into effect. And here we're dealing with a national issue of the greatest importance, which the judge recognized. The Constitution says that it's mandatory. The judge recognizes it currently inimical to the judiciary and the independence of the judiciary, but you proceed to leave it hanging um, so that it is unclear as to what is the time period for which this president can initiate this process. I believe that that is the sort of issue that I was addressing this afternoon. But nevertheless, we have emerged, I believe, successful. I want to thank Selwyn for his significant contribution that he continued to make um, to these matters and to freeing Guyana from executive lawlessness.
Thank you so much. Executive lawlessness. Yeah, we're seeing that. Selwyn, you want to go ahead concerning the difference between this case and Justice Gino Prasad? Breath of fresh air for most Guyanese to have watched.
Well, certainly Gino Prasad, Justice Gino Prasad, His Honor, interpreted the Constitution on the 24th of March, 2023, in a way that the Constitution should have been interpreted. When Justice Gino Prasad spoke about the insulation of not executive, but independent office holders, he made findings, orders, and declarations that brought effect to that. Right. In this case, the judge went along the same directions, but she didn't make findings, orders, and declarations that would bring effect to these important constitutional office holders. And Senior Counsel Ford raised an important issue of the letter that was written that put forward these two constitutional office holders for appointment. The judge should have reasoned with that letter and the response of the executive to Gil DeShirer, which was a non-response. So she should have reasoned with that, and she should have determined in the circumstances whether this was a consultation that was initiated by the leader of the opposition, and whether the president failed to clap hands. Because the Chief Justice said, hey, one hand can't clap, it takes two hands to clap, right? Well, in this case, the leader of the opposition clapped and the president didn't clap back, or
Didn't clap
at
back
least he
for
put his hands out to clap.
obvious reasons. Perception is that the regime is uncomfortable with the acting chancellor, and we can discuss that in some other occasion. But Mr. Ford, the clapping back, we didn't get a clap back from the regime because, for obvious reasons, Mr. Ford, now as we prepare to close off here this for this brief session, we want to touch on all of the forgeries we're hearing about, dozens upon dozens of fake names and forging of documents, people's names and dead people and so forth. Where do we go from here as it pertains to the local government elections? And mainly, the chairman of the Elections Commission is very, very quiet on all of these irregularities. Not allegations, but we're seeing it blatant irregularities.
Mark, an election begins from the time the date is fixed to the declaration of the results. And to the extent that we're having these serious issues which go to the integrity of one aspect of the elections, which is the nomination, a very important aspect of it, is an important aspect of the entire electoral process. And these issues which are emerging in terms of the fraudulent activities, fraudulent names, the forgeries, go to the entire integrity of the elections itself. As I've said, and I just want to make it point again, it is important. The nomination period is important, and getting it right is important. Now, Mark, the nomination process is flawed because the underlying list of electors is flawed. We have not engaged in any process to remove fraudulent names, and the Elections Commission has not engaged in any process to have any verification done that the persons who are on the list are in fact legitimate names to be dared. And there we're speaking about persons who are deceased. But in relation to persons who may be legitimately on the list, there's no process by the Elections Commission itself that they can engage in any process to verify whether these are in fact legitimate signatures. And GECOM has previously taken, in the last local government election, taken the position that they're not a fingerprinting investigating department. A very similar posture to that which the chief elections officer had to undergo by way of instructions from Claudette Singh herself during the period of recount, that she can't engage in any analysis as to what was coming out of the box because they don't have any investigative or judicial power. But what is clear, Mark, is that the Elections Commission under the Constitution is obligated to produce a credible election, which includes engaging in any processes necessary to ensure that they can bring and reduce this fraud. I have pointed out yesterday in comments on the protest line that much of what is happening is largely to be placed on the lap, under the foot of Claudette Singh as the chairman of the Elections Commission. As the commission is currently constituted, it's made up of 7 persons. The world knows that in the context of our Elections Commission, 3 opposition, 3 government, and Claudette Singh as the chairman. And she has voted consistently with them on any and every issue that deals with biometrics, from biometrics to the mandatory preparation of the list, to the removal of dead persons from the list. So basically what we have, and I want the public to really understand this, that we essentially have a one-person commission because it is always divided. The issues are always incompatible with each other. And so it comes down to one single person making these decisions that affect the nature and quality of our democracy, that affect the nature and quality and the integrity and the credibility of our electoral system. It comes down simply to Claudette Singh. And to that extent, I believe that she has failed to engage in any process that is redemptive, that will see the Guyanese people having any degree of confidence in her. I learned sometime today, Mark, that the Commission of Inquiry report in relation to the March 2020 general regional elections is to be laid over with the people who occupy the office of the president and state house today. And I would be very disappointed if that report does not engage in a serious analysis and condemnation of Ms. Claudette Singh herself and her point out her inefficiencies and failures to occupy that office. I believe that it is time that Ms. Singh, who I've had the highest regard for, but in this current context, I believe that it is best that she simply resign and leave this situation alone.
Thank you so much, Mr. Royce. Ford will go as we prepare to wrap up here. Mr. Peters, take a bite of that. All the forgeries and things are not looking good on the part of the PPP at all. Your take on the way forward for the local government elections and the reason you believe that GECOM and GECOM's chair is so silent on these glaring irregularities.
Well, we have a case before the Chief Justice, and the Chief Justice is supposed to come down with a ruling on a case so well argued by Senior Counsel Ford. That decision comes down on March 11th. But I have to admit that May 11th, sorry. Sorry about that. Yes, so stay tuned for that, because I'm sure the Chief Justice isn't in a vacuum and she's hearing what's happening with the forgeries and the dead people and so on, and the people who are overseas. That's a disappointment that has occurred. It's certainly somebody commented on the chat about democratic values and how it's going down the tubes in Guyana, and certainly if we're engaging in all these sort of mechanisms to win, then it certainly places our democracy at risk. I think given all the stuff that has gone on with these lists, that there needs to be some concerted action so that the election is free and fair, free from fear. The issues of people being paid to wear red T-shirts and being coerced to participate in political rallies because of their employment is quite troubling. And if it's true, some action should be taken against those who engage in those sort of conduct. The Commission of Inquiry, I can say that I have no confidence in the Commission of Inquiry and its report. I didn't see I didn't see it as a full ventilation of the issues that took place in the elections in the way that, for example, the prison inquiry was that I participated in, or the Linden Commission of Inquiry. Even that was well past the mark of this particular commission. So I'm not sure that I have confidence that that report is going to be in any way satisfactory to a significant portion of the population. It might be satisfactory to those who pay the piper or pay the judges, but it's not going to be satisfactory to all the constituents. Actually, they wanted me to appear before that Commission of Inquiry, but they wanted me to appear when I was in Guyana. They weren't going to pay my airfare and my hotel to be in there. But if I was going to pay my hotel and airfare to be there, they'd have me, and that was not going to happen. So they didn't heard from me at that commission of inquiry. But that goes to show, that tells me as well that that commission, and they could have done it by Zoom. I didn't even have to fly to Guyana to give evidence. They could have heard my evidence and other people's evidence by Zoom, but they didn't do that. So I'm skeptical about them, skeptical about that report, even skeptical about the people who they had in certain roles in that commission. So I'm sorry.
And let me ask you this: a lot of people, in terms of the results of the 2020 elections and the fact that the PPP and their surrogates and their supporters and so forth are basically bawling out for the opposition to present their SOPs. We are not hearing that at all. Are you, Mr. Peters, and I'll ask the same question to Mr. Ford as we prepare to wrap up. I know I've said this before. Skeptical about the results of the March 2020 elections.
Well, I'm not skeptical about the initial results. I'm not skeptical about the elections itself because, as you know, I was on the ground in Guyana during the elections, and I was an observer in various regions. I personally felt, and I have not changed my views on it, that the election was free and fair and free from fear. What I felt happened is a total breakdown from March 4th until August 2nd. Whatever broke down in those processes in Region 4 significantly contributed, assuming that the PPP rigged the elections in other regions of Guyana, assuming that there were any irregularities on the part of the PPP during the elections. It would lay at the feet of the lack of due diligence on the part of the then party that was in government, because I was there, as you know, I was there at the GECOM command center, and even on the evening, on the evening or on the morning of all the significant events that happened, the PNC, the APNU, and the AFC were remarkably absent. I was amazed when we were at the GECOM Center between March 4th and March 5th, when a lot of significant events occur. There were very few people from the APNU, AFC that were there, and there were tons, almost hundreds of people from the PPP that were there. So it was problematic that there wasn't a significant amount of involvement, a significant amount of due diligence on the part of the people that were in government that are now in opposition. And it still remains the scene. It still remains the case because you can see, I mean, Mark, you're very critical of the opposition because you can see the people who are doing the work. Rosedale Ford, an eminent counsel, is one of the most prolific litigators and persons holding the government accountable. And he's not being paid for his effort. He has a family to support. There are tons of lawyers who benefited while the APNU, AFC were in government, and you're not seeing them. You're seeing somebody like Rosedale Ford. So, if he doesn't litigate a substantive issue, it's not litigated. And
Definitely kudos to Roysdale Ford for all of his work. Every day we're hearing some legal action, and Roysdale is definitely top the list by far. Now, I pose that same question to Mr. Ford concerning all of the irregularities we're seeing now in the local government elections, which mirrors almost the set thing that came out of the recount process. Dead voters, absent voters, stuck ballot boxes. Now we're seeing hundreds upon possibly hundreds of forged signatures, and people are coming out and complaining. Mr. Ford, how much different is it now we're seeing compelling evidence what may have happened in the 2020 elections?
Mark, one of the things that I would like to say is that the March 2020 elections would be a watershed elections for many, many reasons. It is the only election that would have had a recount, and the recount of that elections did a number of things. apart from the fact that we believe that the recount process was not lawful, and Selwyn and I and Mr. John Jeremy, senior counsel, and other lawyers are currently in the Court of Appeal. We have completed arguments on that, and that process itself would have been a deviation. That is what we're saying, a deviation from what would have been the result of the election. So Mark, let's go back to what happened during the recount process. You just had it up there, and that is what the recount generated. We're seeing substantially the same thing happening now before the actual voting at the local government elections. And I believe what we're seeing now is being informed by our experience at the March 2020 elections. And what it indicates also is that this is about the voters list. And that is the source of the problems. It is not the solution to everything and all the possible fraudulent activities that can be undertaken by a political party that is committed to fraud, but it is substantively a significant and primary basis for all the problems that we're seeing. For example, Mark, I'm looking at the screen that you have up. Please don't take it down as yet. 61 dead voters were discovered, 4,864 absent voters, 1,278 persons vote without missing sources of identity. Just calculating those three figures alone, Mark, it constitutes at least one seat in the National Assembly. One seat. Sufficient to change the difference in the governance of the country and the direction of the country. Just simply on the figures alone that you have up there is sufficient to change the direction of this country. And to that extent, I believe that the PPP took advantage of the fraudulent list that was the core and central problem of the March 2020 elections, and still continue to plague this country until we can move to the point of having a bio element incorporated into the list and a verification in support of that process. We will continue to be plagued by these problems that will go to the core of our democracy, the core to our electoral system. Our citizens will become more and more disillusioned, and the results of the elections will become increasingly skewed and not representative of the true will of the Guyanese people.
Well said, both gentlemen. Quickly before we go, I'll commit a sin if I don't ask you guys quickly, because we really have to go. I know you guys are busy, have some other matters. Mr. Peters, quickly, your take on this, and where should we head? Should she proceed and leave, resign? What's your take, sir?
Well, I mean, it certainly indicates, certainly Guyana had this sort of perception that they were good with the United States and that the United States was in their corner. You know, they have the United States. I can't comment too much because I don't want to be accused in any way of interfering in international and bilateral relations. But certainly, let me say this, that the situation with the Home Affairs Permanent Secretary raises serious questions that the government needs to answer. I think that's how I'm going to leave it at that.
All right, but you wouldn't go as far as to say that it basically Guyanese would not have confidence with her sitting in that position, and by virtue of that, she should step down until an impartial or independent investigation.
Well, certainly, it depends on if accusations are raised against her. If serious accusations were raised against her, that certainly goes to her integrity and fitness to hold the office, then she should have been asked to step aside. I mean, look, they suspended the whole Police Service Commission simply because they appeared in court, a legal process that they weren't prohibited from appearing in. They suspended them all because they appeared in the Ganis Mayapal case. So this is not the Ganis Mayapal case. This is a case where somebody is intercepted by border agents, is interrogated by the authorities in another country, and their phone is seized. Who knows what information was on that phone, and so we have to wait to see how this is all going to end, and we have to, while waiting to see how it will all end, maybe she should step aside. I understand she's traumatized by the events.
Okay.
If she's traumatized by the events, then she can't properly perform her functions of office anyway. So she might as well take the time needed to catch herself and have somebody competent perform the role.
All right, well said. Quickly, Mr. Ford, your takes. I know you have mentioned you put out a report. You have been very active in terms of your comments on this situation. Thus far, she's still there. No report coming from her as to why she was pulled over by U.S. law enforcement agents.
Yes, Mark, I agree with Selvin completely. When he made the comparison between the removal of an entire constitutional commission, which was deprecated by the judgment of Justice Gino Prasad, you remove an entire constitutional commission because they participated in litigation, constitutional litigation, of which they're entitled to, concerning their funding. And you remove the entire commission, even in breach of the Constitution. You remove the entire commission, you set up no investigative body, you just clean everyone out, clean them out. And here you have Miss May Toussaint Jr. Thomas here, her phone being taken away, all the reports coming out in public. We don't know exactly up to now what is the reason why all of this was happening. There's no obvious investigation taking place. You would believe that the government would ask her to just simply sit it out and to have an independent investigation done. Certainly this requires a commission of inquiry. Mr. Ali, the president, is very fond of them now. He could certainly appoint one rather quickly. And this is the issues that go to integrity in public office, in terms of ensuring that a senior public servant, the permanent secretary, who was also a candidate on the PPP's list, I might add, is properly investigated, and public could have confidence in her retention of the office. I'm not saying that she must resign, because I don't know what would be the circumstances in which all of this would have been happening and unfolding, but certainly sufficient to take a break and a step back. And even if the government doesn't want to do it themselves, I believe that it's sufficient for Ms. Thomas herself to consider it prudent to do.
All right, someone mentioned that she was traumatized. I tell you guys this here. What she has done, or what happened to her, has traumatized the entire nation. And in my opinion, she should just basically call it a day, because U.S. law enforcement agents are not going to question somebody. You guys are the lawyers here. I am not. And it's not a matter that is as innocuous as it may appear, because to question somebody for 3+ hours and then confiscate their telephone, it doesn't tell a good story there at all. God in heaven knows we're hearing that lots of cash, and I'm not sure, that she was allegedly carrying, and we are awaiting a report coming from her. What is conflicting, though, is a report in Stabrook News, I believe, that says that, quoted government sources saying that she was not on government business. But yet the minister of which she falls under, Mr. Robeson-Ben, has said she was basically on ministry business. The conflicts there, I don't know what's happening, but they need to speak the truth before the truth actually spills out. Gentlemen,
Mark,
yes,
Mark,
go ahead.
I have to go back into court. Sorry, I have to leave.
Thank you for your time, though. Appreciate it, Selwyn. Thank you so much, Mr. Ford, as well. Keep up the good work. Keep us informed on the ground. We see that you're very busy there. Thank you, sir, for your service.
Thank you, Mark. Thank
Appreciate
you to your audience for having us and listening to us.
Yeah. All right, Senior Counsel there, Roysdale Ford, and Member of Parliament as well as Selwyn Peters, Attorney at Law Selwyn Peters. This evening we will have 9 o'clock. 9 o'clock we'll have, hopefully we'll have our other in-house lawyer, Shalon Washington, with us, hopefully. And we will have Lincoln Lewis, veteran trade unionist. He wants to talk about a lot of things, the forgeries, dead people's names, all manner of things. We want to have that. But for now, God bless you all. See you later this evening. Bye-bye.
And you're confident that you're going to deliver credible and fair elections?
Of course. Only one way I know, and that is the correct way. I do not believe in, there's so much negative things in the newspapers. I will not sell my integrity for all the oil in Guyana.
Hello, this is attorney Shellen Washington, owner and founder of the Washington Law Firm, located at 455 Utica Avenue in Brooklyn, New York. We're specialized in medical malpractice, personal injuries, matrimonial law, and landlord and tenant. If you're in need of legal representation, please give us a call today. The number to call is 718-877-3100. Consultation is free at no cost to you. So call us today to see if we can be of any assistance to your legal needs. Again, the phone number to call us is 718-877-3100.